Welcome to this employment status online presentation, produced by Halewood Advisory Services Limited. This presentation considers the distinction between the self-employed, employees and workers, their rights and their responsibilities. I am Susan, your online presenter. If you have any questions, please contact us by email. Employment law recognizes three main categories of persons who undertake work for others. A. Employee. B. Worker. C. Self-employed. We have all come across these terms in our working lives and may have our own understanding of what these terms mean. But what do they mean in law? Employees are employed under a contract of employment, sometimes referred to as a contract of service, as opposed to the self-employed who are employed under a contract for service. A worker may be employed under either of these forms of contract. However, there are no definitions of the terms contract of employment, contract of service or contract for service given in the various Acts of Parliament and statutory instruments relating to employment law. There is no legal requirement that these contracts be in writing or all the terms of the agreement contained in a single document. However, confirming the terms of any agreement in a written document or documents may prevent future dispute. It should be noted that an employer is required by Section 1 of the Employment Rights Act 1996 to issue to an employee a statement containing the main particulars of the terms under which they are employed. This document itself is not a contract of employment but may be used as evidence to what the terms of the contract are. In the majority of cases it will be fairly easy to establish who is an employee and who is self-employed. If you took your watch into the local jeweler for repair, you would probably be in no doubt that the jeweler was self-employed and he was not your employee. If you had a burst pipe at home and engaged a plumber to undertake the repair, again you would probably be safe to assume the plumber was self-employed and had not become your employee. You own a factory and employ Fred to work for you for 40 hours each week, Monday to Friday, allowing 4 weeks paid holiday a year. You would probably have no doubt that Fred was your employee. However, not all situations are as straightforward. You engaged a cleaner to undertake work in your house 2 days a week on a regular basis. Is the cleaner your employee? What of the gardener who comes 1 day every fortnight to maintain the garden? Are they self-employed or your employee? You require a temporary laborer to work in your factory, to cover holiday absences, for a 4-week period. You contact the local employment agency, who send Robert along to work for you. Does Robert become your employee? Is Robert the employee of the agency? In an attempt to provide some employment protection to persons who fall in this grey area, certain employment protection rights now recognizes an intermediate class of person, the worker. Today we will be looking at how the courts and tribunal distinguish between the self-employed, employees and workers, and what difference employment status makes to a person's rights and responsibilities. We will initially consider this question by considering the statutory definition of an employee and then go on to consider how the courts and tribunals decide who is an employee. The Employment Rights Act 1996 at Section 230. 1. Defines an employee as an individual who has entered into or works, or where the employment has ceased, worked under a contract of employment. This is not very helpful. Over the years the tribunals and courts have developed various tests to be applied when deciding employment status. These have been developed as the way in which we work has developed. The original test, developed by the courts in 1880, was the control test. This test simply set out that a servant is a person subject to the command of his master as to the manner in which the work shall be done. As the nature of working relationships developed, the control test alone became unreliable in deciding whether or not a person was an employee or not. For example, a hospital doctor is not under the day-to-day control of his employers as to how he undertakes his duties. For this reason, the organization integration test was developed. In Stevenson, Jordan and Harrison Limited v. McDonald and Evans, 1952, it was stated, under a contract of service, a man is employed as a part of the business, and his work is done as an integral part of the business. The control test and organization integration test were subsequently developed into the economic reality test. This test was formulated in judgment in Ready Mixed Concrete, South, Limited v. Minister of Pensions, 1968, when it was stated there should be two positive conditions to be met for a person to be considered an employee. 1. The person should undertake the work personally. 2. There should be a significant degree of control over their work. It was also stated there should be no inconsistencies in the contract that point to some other employment relationship. Later cases, for example, Montgomery v. Johnson Underwood Limited, 2001, have developed this test further, and courts and tribunals will now normally require a third positive condition when deciding a person is an employee. The third condition is that of mutuality of obligation, that is that the employer is obliged to offer work to the employee and the employee is obliged to accept the work. Whilst one of the decisions we have just looked at dates back over 140 years, the principle established in this and the other decisions are still relevant today. How the courts and tribunals establish employee status is summarized in this slide. We will now consider the issue of inconsistencies, as we look at self-employed status. The courts and tribunals have often been asked to consider the question, is this person self-employed? There is no simple test that can be adopted. The tribunal or court will look at all aspects of the relationship between the person doing the work and the employer. One of the leading cases is Hall, Inspector of Taxes, v. Lorimer, 1994. In judgment in that case, the Court of Appeal gave guidance to other courts and tribunals on the factors that should be considered when deciding whether a person was self-employed or not. See list on slide. In the normal relationship between a self-employed person and the person for whom he is performing the work, the employer, the task will be set by the employer and will then be undertaken with minimal or no supervision. The self-employed will normally provide their own tools and equipment. Does the person do the work himself, or did they get someone else to do it, or could he get someone else to do it? Is there a financial risk on the part of the person doing the work? Can they increase their earnings by operating more efficiently? Do they issue invoices for work done? Do they work for more than one employer? Would the business keep its identity if they did not perform the work? In Market Investigations Limited v. Ministry of Social Security, 1969, it was stated, the fundamental test to be applied is this: is the person who has engaged himself to perform these services performing them as person in business? What are the intentions of the parties? In Young and Woods Limited v. West, 1980, the Court of Appeal said the label the parties give the relationship was only decisive when the other factors were of equal weight. We now know how the courts and tribunal decide who is an employee and the factors they will consider when deciding if a person is self-employed. But how do they decide who is a worker? Let us first look at the statutory definition. The definition of a worker shown in the slide is a summary of that used in the National Minimum Wages Act 1998 at Section 54. The same definition is used for the purposes of the Working Time Directive 1998 and the Employment Rights Act 1996. Other acts of Parliament and regulations refer to the National Minimum Wage Act 1998 definition of a worker or give their own broadly similar definitions. The full definition of a worker contained in the National Minimum Wage Act is: a worker means an individual who has entered into or works under a contract of employment, or b. any other contract, whether express or implied, and, if express, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or service for another party to the contract whose status is not by virtue of the contract that of a client or customer of any profession or business undertaking carried on by the individual. Let us now look at what the courts have said in connection with workers. In the judgment in Byrne Brothers, Form Work, Limited v. Baird and others, 2002, a case concerning whether or not Baird and other were self-employed or not, the court stated that legislation, in that case the Working Time Regulation 1998, had created an intermediate class of protected person who were neither employees or self-employed. The court went on to say a worker's dependence on the employer was essentially the same as that of an employee. This would appear to indicate that a degree of control over the worker, by the employer, is still a requirement. A number of decisions of the courts and tribunals, for example, Willoughby v. County Home Care Limited, 1999, have indicated that for a person to be afforded protection as a worker there is no requirement for mutuality of obligation. Consequently, an agency worker who can pick and choose which assignments he undertakes may not be able to show he is an employee, but would probably qualify for protection as a worker. Putting together the statutory definition and the decisions of the courts, it appears there is only one positive condition to be proved to show a person is a worker. That is that they undertake the work personally. There is no requirement that there be mutuality of obligation as there would be in establishing employee status. However, they must not be carrying on a profession or a business, in other words they must not be self-employed. In many situations this is probably the most difficult part of the test. So why does the difference matter? Dependent on an individual's employment status, different employment rights and responsibilities apply. Being an employee can be seen as being the gold standard. An employee benefits from protection from personal liability for any damage or injury caused during the course of their employment. Employees enjoy a full range of employment rights. At the other end of the scale is the self-employed person who can be held personally responsible if they cause damage or injury during the course of their employment and enjoy very few employment rights. Sitting somewhere between these two extremes is the worker. Vicarious liability. If an employee or a worker causes injury to a third party or damage to property during the course of their employment, then the employer will be responsible for putting matters right and may be ordered by a court to pay damages. The employer would be responsible for ensuring they have the necessary insurance to cover injuries suffered by employees and third parties. A self-employed person will be responsible for the consequences of their own actions and the actions of those, if any, working for them. They would, normally, be responsible for arranging their own public liability insurance and insurance to cover injury to those working for them. Duty of care. Employers have a duty to ensure employees and workers are properly trained, have the correct equipment and have a safe working environment. Most of these issues are covered by health and safety legislation which is not covered by this module. The self-employed will be responsible for ensuring they carry out work in a safe manner and that health and safety legislation is observed. They will, normally, be responsible for the provision of their own tools and equipment and ensuring these are fit for purpose. The area that concerns us in this module is that of individual employment rights. This is not intended to a definitive statement of the legal rights of the self-employed, workers and employees and is intended only to provide an indication of how legal rights will vary dependent on employment status. Discrimination. Both workers and employees have protection from discrimination in employment, sex, race, disability, sexual orientation, religion and belief, gender reassignment, and age discrimination. This protection covers the selection process, promotion, events during the course of their employment and following recent decisions of the courts post-termination discrimination, example, the provision of a reference. The manner in which the discrimination legislation has been drafted affords protection to the self-employed, with the provision that they are performing work or services personally. In Mirror Group Newspaper Limited v. Gunning, 1986, Ms. Gunning applied to MGN to take over her father's agency contract for the wholesale distribution of newspapers. Her application was refused. She claimed the application had been refused because she was a mother with family commitments and this amounted to unlawful sex discrimination. Her claim failed. The Court of Appeal said that for the employment tribunal to have jurisdiction to consider a claim, a contract must have as its dominant purpose the execution of personal work or labor. In the particular case, there was no evidence that Ms. Gunning would be carrying out the distribution of newspaper personally. Working Time Regulations 1998. The regulation cover issues relating to holiday entitlement and working hours including rest periods and breaks. The regulations apply to both employees and workers. National Minimum Wage Act 1998. As the name suggests, the Act is concerned with minimum rates of pay and, like the WTR, applies to both employees and workers. Unfair dismissal. The general law relating to unfair dismissal is contained in the Employment Rights Act 1996, ERA. The ERA contains a large part of the legislation relating to individual employment rights. The Act is split into 14 parts. Some parts apply to employees only whilst others apply to both employees and workers. The law relating to unfair dismissal is contained in Part 10 of the Act and applies in respect of employees only. However, employers should take care the right to be accompanied at a disciplinary hearing is extended to workers. Under certain legislation, a worker may be able to show he has suffered a detriment following termination of a contract. For example, if a worker can show the termination of his contract followed them making a protected disclosure, whistleblowing, they may be able to claim damages for the detriment suffered, compensation being awarded in a similar manner to an unfair dismissal claim. Redundancy payments. The entitlement to a redundancy payment is contained in Part 11 of the Employment Rights Act 1996 and again only applies in respect to employees. Protection of wages. Wages are afforded special protection under Part 2 of the Employment Rights Act 1996. This part of the Act applies to both employees and workers. Reduced to its simplest, the Act provides that an employer cannot make a deduction from the agreed amount of a worker's or employee's wages unless the deduction has been authorized in writing by the worker/employee. The contract allows for the deduction or the deduction is authorized by statute. This is not to say a self-employed person would have no redress if they did not receive the correct payments. However, their claim would have to be to the county court either for breach of contract or the recovery of a debt.